Hello, my name is Alan Rycroft and I want to take 2 minutes to introduce WorkLaw's August newsletter. The COVID-19 pandemic has been stressful for many people. Fear and anxiety are unavoidable and it's caused strong emotions. And depression is taking its toll. And for this reason, the article in the August newsletter is about depression, which is not just a little form of ill health like flu. In certain circumstances, depression fits into the category of disability, which is a ground on which Section 6 of the Employment Equity Act prohibits unfair discrimination. In particular, we look at a recent decision by the Labour Appeal Court, which spells out that a person alleging unfair discrimination on grounds of depression has to establish what they call factual causation and legal causation. I think you'll have to read the article to understand those two concepts. As usual, our newsletter profiles 3 new cases. The first case involves incompatibility between managers, and the employer decided to deal with this not as a form of incapacity, but through an operational requirements dismissal. The Labour Appeal Court confirmed that the procedure was unfair. The second case deals with what must be proved before a court will find there has been contempt of court by a union which doesn't comply with a strike interdict. When you read this case, you'll discover that the requirements for a contempt order are very strict. And the third case is a constitutional court decision which deals with whether or not there has been a transfer of employment contracts in terms of Section 197 of the Labour Relations Act. In this case, one employer took over the buildings, assets, intellectual property of another company, but said it didn't need to take over the 68 staff. The Constitutional Court ruled otherwise. An interesting judgment. I hope you find the newsletter stimulating and interesting. Cheers.